Good morning, everyone. Take risk in your life. If you win, you can lead. If you lose, you can guide. I, Yushra Patel, on behalf of Center of Innovation, Incubation and Entrepreneurship, consider it a great honor to welcome our chief guest and keynote speaker, Mrs. Tanu Singh. I heartily welcome you, ma'am. I also welcome our faculty members, Anuja Narvankar ma'am and Tensi Thomas ma'am, and my dear Vivian. I welcome you all. Now, I would like to call upon Amir Pathan to take over.
Thank you, Yusha. Good morning, everyone. Myself, Amir Pathan, Head of Public Relations, ESET. I'm here to give an introduction on Vivek College of Commerce and Center for Innovation, Incubation and Entrepreneurship. Vivek Education Society is a charitable institution set up in year 1961. Had established Vivek Vidyalaya in 1962. Had followed it up by starting junior college. Vivek College of Commerce has started in year 1986. It is recognized as vibrant institution continuously working for the cause of education. Center for Innovation, Incubation and Entrepreneurship was firstly known as ESET, that is Entrepreneurship Cell. It was started on 11 December 2018 and later got developed into Center for Innovation, Incubation and Entrepreneurship on 20th December 2021. Vivek College of Commerce is first college in Maharashtra to inaugurate an incubation center under MITSC, Maharashtra Information Technology Support Center. We have registered ourselves under Ministry of Education Institution Innovation Council and have also completed and approved all our quarter 1 and 2 activities. Under IIC, we also have Atal Tinkering Lab schemes in which we do mapping in different schools. So now, let us know about our chief guest and keynote speaker, Mrs. Tanu Singh ma'am. She is a successful entrepreneur, keynote speaker, and Indian patent agent, and also startup IPR facilitator. Our keynote speaker, Mrs. Tanu Singh ma'am, has done her education in different and from renowned institutions. She has done her BTech from Dr. D.Y. Patil Institution of Engineering and Technology, Pune. MBA IT from International Institution of Information Technology, Pune. And PG Diploma in Patent Management, Intellectual Property Rights from Global Institute of Intellectual Property. Her experiences are, she has been patent analyst for 2 years and senior patent analyst and business development management for 3 years in Origin IP Solution LLP Bangalore. Currently, she is founder of Intellect Vidya Solution. It was honor, ma'am, to introduce to you in my team. Thank you, ma'am. Now I will request you to take over the session. Thank you, ma'am.
Thank you so much. Thank you for the warm welcome you have given. So I am here to interact with you all and talk on few topics related to intellectual property rights. So I hope you all will get basic knowledge about IPR. We'll touch on few topics, and then if you all have any questions, any doubts, please feel free to ask at the end of the session. So let me share a PPT first before I start my talk. Is my screen visible? Are you all able to view the PPT which I have displayed?
Yes.
Thank you. Thank you for acknowledging that. Okay, so let us start our talk with a very positive note. So here we can see that India has shown a considerable growth in the innovation index list. So we can see from the year 2015, it was in 82nd position, and in the last year, that is year 2022, it has reached 40th position. And it is growing considerably, which is a very positive note for our country. Now, before we, start with intellectual property rights, So first let's discuss like what is property. So property can be divided into categories. One is tangible property and the other is intangible property. So tangible property is anything which we can touch. So any asset which you can remember, like jewelry, land, building, everything will come under tangible property. But what is intangible property, which is the topic of discussion for today's session? So intangible property is something which we cannot touch. So it is always in the form of an idea or concept. So basically they are non-physical asset. It is a very powerful and important asset, but it is a non-physical in nature. So basically, if we talk about innovation, so it basically it is in 5 stages. First is you have to realize the invention in hand. Then you have to properly define it, document it, further develop on the idea. Then you can prepare the prototype and finally the testing, like how the invention is working. So where does the patent comes into the picture? So patent comes into the picture on the very third step, because to file a patent, it is not mandatory that you have to be ready with a prototype. So once you feel that your invention is ready, completely documented in its implementation form, then you can go for protecting your innovation or idea, so that nobody else will copy it or nobody else will make use it. You will get an ownership of your invention or your innovation. So now we spoke about what is property, what is innovation, what are the stages, basic stages in innovation. Now we are talking about intellectual property rights, which is the main topic we are discussing today. So what is intellectual property rights? So any property that is generated through the creation of mind. So we all know, our great leaders have said that any technology that exists in the world today is creation of someone's mind. Okay, so intellectual property addresses that. It addresses a good innovation, a good invention, a good technology solution that is provided by someone's own intellect. So the legal authority granted provides rights to the owner to make use of such intangible property. Now, when you come up with such a good invention or technology, then you should protect it. So here the intellectual property rights comes into picture. So there are laws, there are patent laws, there are different laws that helps you to protect your innovation so that you get a legal right or legal ownership over it. Now, under intellectual property rights, there are different kinds of rights. There are different kinds of IP that is selected based on the nature of your work or innovation. Now, first comes the patent. Patent is also called the king of the intellectual property rights. So patent is given for the technical feature of a product or the functionality of a product. Okay, for such as inventions. Copyright is given protection for the expression of the idea, like any literary and artistic work, like books, music, song, such kind of work. Then industrial design. Industrial design help us to protect the aesthetic look, appearance, or the design of the product, not the functionality or technical features. So next comes the trademark. So trademark protects the name of the company or the product. It helps to distinguish, one's company from that of other in the market, or it helps to distinguish a service from other related service in the market. Then comes geographical indication. So it is given to a community. This is a right which is given to a community for a particular product grown in a particular geography with the help of group of people. Then last is the trade secret. Trade secret is also a unique form of IPR, wherein the information is not revealed and we do not document it and submit it with the patent office. In fact, we keep the document secret. So until the secrecy is maintained, the trade secret is there. So as I told in the beginning, so there are different kinds of IP which is protected under different acts. There are different acts laid down by the government to take care of these work. So these acts were enacted way back in 1800, and with time to time they are amended also. Changes are being brought about in the act based on the requirement and need of the inventors, country, government. Based on it is very flexible. So I already told about different kinds of IP. Now we will discuss little bit in detail, like what is copyright. So copyright is the, as I told you, it protects the expression of the idea, like how a writer is writing the book, or how a person creates a lyrics of a song. So basically, what copyright does is a same content or a same topic can be represented in different ways by different people, because everyone will have their own way of representing and expressing the data. So that is what is protected under copyright. So copyright registration comes under Berne Convention. So as I told you, there are different act, treaties, protocols related to each of these kind of IPR. And these IPR, like patents, copyright, they're always territorial in nature. What I mean to say is, like, suppose you file a patent for one of your invention in India, then your patent is valid and enforced only in India. You cannot claim that right outside India. So based on the requirement, the IP should be filed in different countries based on the requirement. And then there are different timelines also for the protection. For example, copyright is protected in India for author's life and 70 years after their death. So this is the timeline for copyright protection. Then once you get a copyright, you should always put a notice, a disclaimer notice, so that the general public will come to know that this is a copyrighted product. So there are ways to write it, like, as the last line you can see, the C inside a circle, then the year in which you got the copyright or the copyright was created, and the company name, all rights reserved. So this is a kind of notification to the public that, this particular thing is copyrighted. So so here, for example, now if I have a copyright for a book, then of course I have the rights over that book, but I can always transfer it to the publisher. I can ask him to publish it on my behalf. For example, a Ramayana story. So a new version of Ramayana story, we will see a lot of new version of Ramayana books or Ramayana series or Ramayana, movies. But the original author who has written the book should be given the credit, because he is the original author, or he has the copyright ownership over that book. So these are the different kinds of work that can be protected under copyright. So first comes the literary work, which include books, paintings, sculptures, photographs, drawings, movies, music, choreography, sculptures. These are all different kind of works that can be protected under a copyright. So now comes the trademark. So trademark is always given for a name, a word, or a symbol. So if you're registering a new company, as a startup, you're registering a new company. So now you don't want that, after a few years, you come to know that somebody else copied the name, or somebody else used the same logo which you had created for your startup. So how do you prevent that? By filing a trademark. So if your name is unique, if the logo of your company is unique, it is, it is not similar to any of the existing logos, then you qualify to file for a trademark. And it helps you to maintain your brand and image in the market. So there are certain criteria again to file for a trade. For example, the word should be unique. For example, Doordarshan. Doordarshan was a unique name when it got registered. It should be distinct. So it should not be very generic, or name of a person or a place. It should be unique. Then preferably it should be a non-dictionary word. It means it should be an invented word. For example, Baiju, Zoho. So these are some good example wherein these are self-invented words. It does not exist in the dictionary. If you see, it does not have any meaning, but it is distinct for their service and for their company. So it qualifies as an example of a good trademark. Then it should not be a device or a symbol like common shapes. Then it should not be related to any religious symbol, for example, Om or Ashoka Chakra. Then it should be non-descriptive. Like your uh, your trademark should be such that it should not be describing your service or the company. So it should be distinct. For example, and you should avoid using adjectives like efficient pen or tasty ice cream. So these kind of things will not qualify as a trademark. Again, I told you every IP has a timeline. So trademark is registered for 10 years and it can be renewed every 10 years. So if you keep renewing your trademark, in that way you can maintain it for lifelong, or until you are into the business, you can maintain your trademark. So again, there are, see here, we can see different kind of trademark, like Adidas, it comes under a fanciful name. Then Apple, even though Apple is very generic, right? It's a fruit. But again, Apple for an electronic device make it distinct. So it is a distinct and good trademark. Then descriptive, Pizza Hut. By the name Pizza Hut, everyone knows that it relates to pizza. So such kind of descriptive word is difficult to get trademark, because these can get objections, and we may find it difficult to defend it. So we suggest it should be always distinct and non-descriptive marks and self-invented, self-coined words. Then comes the patent. So I already told you patent is the king of the IPR. Why? Because patent protects the technology functionality of a product. So if you come up with any invention, any new product, or any new process of making a product, or for example, if in case of chemical, if you come up with a new composition of a medicine or a new composition of a paint, so these are some kind of inventions that can fall under patent. So there are basically three main criteria to qualify for a patent. First is your invention should be novel. So when I say novel means your invention, it is not like you have to come up with a breakthrough invention or something completely new or completely different to go for a patent. It is not like that. But you have to have some uniqueness or novelty in your invention. At least one or two feature of your invention should be unique in light of the existing similar patents or existing similar products that exist in the market. So basically, you have to show uh, some technical advancement in your invention. Then second is non-obvious. It should have some technical advantage or economic significance over the existing already filed patents. and it should have industrial applications. So your invention should have advantage and industrial applications to qualify for a patent. If your invention will lack three of this, then we might get objection and we might not be able to get it granted. So that is why at the very first moment when an invention comes into your mind, think of it basis of these three criteria: what I am doing new, what problem I am solving, how my invention is working, is there anything new in terms of technology? So these are some questions which you should ask yourself when you are on the path of innovation. So again, the timeline for patent is, it is granted for 20 years. From the date of filing a patent, it will be, the timeline of the patent will be 20 years. Then I told you there are three main criteria to file for a patent. Apart from that, there are many subject matter which are not patentable. For example, discovery of natural substance. So for example, some mining is going on in some area and they come up with a new compound which was not documented in our Indian history. Then that person cannot claim that I have come up with a new invention, because it is not an invention. It is just a discovery of a known compound. So this will not fall under patentable subject matter. Then mathematical, business method, or computer program per se, like the source code or the algorithm, will not come under patent. But the methodology, the concept, how you're how you are solving the problem, what is the method, that can be patented. Then rearrangement of known devices. For example, you just take one torch and just take one umbrella, fix both of them together, and you say that, this umbrella is novel because I can use it in night, I can use it, to as a light also. So no, because you are not showing any new technology, you are just joining two known things and you are asking for a patent. So it will again fall under non-patentable subject matter. Then mere admixture or combination of two components. Again, for example, in case of composition, we already know one compound which is anti-inflammatory and the other compound which is antibacterial. So for example, you join both of them and it is showing the same effect which is known, anti-inflammatory, and it is helping in reducing the inflammation and it is helping with the bacterial infection. So no, this will again not fall under patent, because you have to show some synergistic effect, either both of them coming together giving one new effect, or you're adding some new ingredient which was not known and which when combined with these two known ingredient is giving a better advantage. So something like that you have to work on your invention. Otherwise, mere adding two mixture with known properties will not constitute for a patentable subject matter. Then traditional knowledge. Traditional knowledge means the knowledge which are there documented in our Indian traditional knowledge library. For example, the antibacterial property of neem, or the property of turmeric. It is all a very known traditional knowledge for India. So if you base your invention merely based on this known knowledge, then you will get a objection under section 3P saying that this is already known and we cannot see any technical advancement, and this will not be able to patent it. So that's how you have to, there are many criterias based on which we have to judge how we can make a particular thing patentable and what qualifies for a patent and what does not qualify for a patent. Then comes the industrial design. So I already told you industrial design is given for the look and the design and the aesthetic appearance of the product. For example, if somebody comes up with a unique shape of bottle, then of course you're not going to protect it under patent, because there is no functionality or technical feature that you're looking to protect. You are just trying to protect the design of the bottle, the look of the bottle, so it will fall under design. So now under design also you have to be considering few factors, like the feature should be eye-catching, it should be new and original, like you are the manufacturer of that design or you are the inventor of that design, then you can go for protecting it under design. Should not be functional or useful, because here we are not protecting the functionality. So it's just the design or the aesthetic appearance of the product that we are looking to protect under industrial design. So we spoke about patent, trademark, design. So now we know that each of these IPR has a different purpose, and based on the nature of the nature of the invention or the nature of the product which you're trying to protect, we will be able to figure out what is most appropriate kind of IPR protection. For example, if you're trying to uh, you know uh, increase your business or brand awareness in the market, then you should go for a trademark wherein you should protect your company name, logo, and everything, so that it helps you in your business. It gives you a competitive edge in the market. And if you have come up with some product which is not new in terms of functionality, but you feel that the design is very eye-catching, then you can go under industrial design. So for trademark, not much of innovation is required. Here only we are protecting the name or the logo which you have created. So it does not require deep innovation. Then there are, I already told, for trademark, it is Trademark Act 1999, which governs the protection of trademark. And for design, it is Design Act, enacted in 2000. Then comes the geographical indication. So I mentioned that geographical indication again again it is different from trademark, design, and patents. Geographical indication, I will explain it with one example. So basmati rice. Basmati rice is one of a GI of India. Why? Because it is believed and it has been proved that basmati rice can be grown only in one particular Himalayan region, and the farmers of that area, they are skilled to grow that crop there. So that crop has a certain distinct taste and characteristics which you cannot get if you grow the same crop anywhere else in any other part of India. So that is why basmati rice is a GI given to the community, a group of farmers who grow this rice in that particular Himalayan region. So this is called geographical indication, and it always helps the community as a whole. Unlike patent, trademark, design, which is always granted to one particular inventor or maybe one particular company, but this is a right which is granted to a community, a group of people. So it helps in identification, it helps in giving that community a recognition of what they are being doing. So what are the advantages of GI? It enhances the reputation of the products, it supports local talent and business, contributes to economic growth for the community. It creates a unique and competitive edge to the product to market the same in national and international platform. It restricts any unauthorized user from using and manufacturing the GI certified products. Then there is another form of IPR which is plant variety. So this is mainly given to recognize and protect the right of the farmers. It encourages the development of new varieties of plants. It stimulates investment for research and development both by public as well as private sector. And last but not the least, it facilitates the growth of the seed industry to ensure the availability of quality seeds. So ideally, what should be for an organization who want to promote innovation, ideally these three steps should be followed. One is IP recognition and creation. So the foremost is identify the IPRs which exist in your organization and document it, further create it, and then once a patent, number of patent, trademark, and these things are filed, it is very important to manage those IPR, because these are the rights which always come with a timeline. For example, now you file a patent, if some notification comes from the patent office, you have to timely respond to that, otherwise your application will get abandoned. So there are a lot of management work that goes behind after filing the IPR. So IP management is equally important. So this is how the cycle goes. First, you have to ideate, document, further develop and work on your idea, develop the prototype, do the testing, and after that, of course, you can commercialize it. You can commercialize your product, you can commercialize your patent so that you get monetary gain from your inventions. So again, this IP life cycle is very important. So once you know that you have technology and inventions in hand, then you should do proper assessment. Based on that, you should formulate your IP strategy. Like what are the kind of work that will go under patent, under copyright, based on the nature of the work that you have done. And then you file it, you manage it, and then you can monetize it in the form of licensing, or you can even sell your patent. So basically, commercialization of IP can be in different form. It can be in the form of knowledge transfer. So it can be in the form of licensing. You can license your patent. So if you have developed a unique technology or a unique patent for which there is a lot of demand in the market, you can definitely license it to one person, one company, or multiple company based on the requirement. Also, there are cases wherein individual inventors who does not have the manufacturing capability to bring the product in the market, they can always license it to some third party, and they can commercialize their invention. So there are different, it is a completely different life cycle when we talk about IP commercialization. We have to first evaluate our IP. So there are different tools available for valuation of your IP. So you have to understand that how much demand is there for this particular technology. You have to forecast what is the kind of revenue this particular technology can create for you. And there are different ways to do that. Like you can do market valuation, you can do cost valuation to understand what is the value of your patent, whom to approach, whom you can approach to license or sell your patent. And these are the different kind of tools that exist to understand, evaluate your IP, and then further license or sell it. So this is a very good way of commercialization or monetization of your IPR rights. So there are different case studies wherein we have seen that how IPR protecting their inventions or innovation helped them in long run. For example, Lijjat Papad, this is a one very landmark case for trademark. Like Lijjat Papad was able to acquire the market in a very wide perspective, and then they could go to making a profit of around 650 crores. So this is a very good example of trademark, like how it became a well-known trademark. It captured the market, and we could see Lijjat Papad in each and every household. Then Dr. Reddy's Pharmaceutical. This is also another good example wherein Dr. Reddy started with the generic generic medicines, and how they invested their time and effort in the R&D, and they went on, innovating new and technically advanced medicines, and how they could get a very good revenue for themselves. So now I would like to talk a little bit about SIPP scheme, which is Startup Intellectual Property Protection Scheme. So this was a scheme launched by Indian government, Indian Patent Office in the year 2016. So they have impaneled, a certain set of patent agents and patent attorneys under their list. And here the startups can directly contact those patent agents, and they will help them in, they will give them advice how to go about the, how to go about innovation and protecting their innovation under various IPR rights. So we spoke about basics of IPR and what should be done. So how do you innovate? What is the correct mindset or attitude you should have? So you should always be innovative. You should always think outside the box. You should always, never copy or plagiarize your content. You should always try and develop your own work. Then whenever you are in the path of innovation, you should always ask these questions to yourself: whether this product will be viable in the marketplace, and what kind of technology I'm working, what kind of technical advancement I'm doing with respect to my product. Is it user friendly? Will it be accepted in the market? So these are some kind of things. If you will keep asking yourself and working on these things, then I'm sure we can generate a lot of new innovations, new product, and good patents eventually. So at the end, what are the do's and don'ts we should follow when we are on our innovation journey? So we should observe IP all around us. So it is said that when you are aware about the existing IPRs around us, then you are at a very less chance of infringing the known IPR. You will be always alert and cautious to come up with something new. Recognize, audit, and commercialize your internal IP. So if you have already set of patents, trademarks, or copyrights for your organization, you should continuously audit it so that you do not miss on any timeline. You do not, your any of your IP should not get expired or abandoned. And wherever there is a scope of commercializing your IP, wherever there is a need or demand of your IP, then you should always grab that opportunity, which will help you to commercialize your invention. So that is all for today from my end. So let me know if you all have any question or anything, please let me know.
Good morning, ma'am. Myself Ashish Nirmal, and my question is: what are the challenges that can be seen in the patent system today?
Challenges in terms of any specific thing you're focusing on, or in general, you want to know any challenges?
Sorry, ma'am, I didn't hear you.
No, challenges in terms of any specific factor you are asking me, or in general, you want to know if there is any challenges?
In general.
Okay. So the challenge is IPR awareness. So as I told at the very beginning, when an individual or a company is at the R&D phase, wherein they are starting with the research and development of a new technology or a new product, at that very time, if they're aware about the existing similar technology, then the chances are very high that they will end up developing something new Okay, so that IPR awareness is lacking, because most of the time we see that people come to us at the end stage. When they are ready with their product and the technology, they come to us to file a patent. So that time, sometime for few innovators, it becomes challenging, because we are difficult to find new. Sometime it becomes difficult to find new features. So that is the challenge, I would say. Thank you.
Ma'am, can you please explain the process for submitting patent applications?
Yes, yes. So, patent application submission, basically it involves mainly three main steps initially. First, we go for a patentability search to assess the novel feature of our invention. Okay. Then we draft the patent application, and then we file it with the Indian Patent Office. So these are the main three steps involved up till filing of the or submission of the patent application with the Indian Patent Office.
Thank you, ma'am.
Thank you.
Ma'am, what is validity period for IPR?
So I told you there are different forms of IPR: patents, copyright, trademark, industrial design, geographical indication. So each one of this has different timeline. Like patent has 20 years. It is valid for 20 years from the date of patent filing.
Okay, thank you, ma'am.
Thank you.
Hello, ma'am. What is the role of IPR in
Hello.
industries?
Sorry, I didn't hear that. Role of IPR in?
Electronic industries.
See, for every industry, electronic industry, when you say you are talking about mobile phones, laptops, right? So we see so many incremental innovation in this field. For example, we know that we buy one phone today, and after 1 year only it gets obsolete. How? Because every day people are innovating. They are coming up with new features which are added to that device. So incremental innovation is very much relevant for electronic industry.
Oh, thank you, ma'am.
Thank you.
Ma'am, questions are over. Thank you so much, ma'am.
Thank you so much. I had a very good audience. They had so many questions. They listened properly, and I hope it will help them in their future.
Ma'am,
Yes,
we are taking over and getting the vote of thanks done.
sure.
Yes, please.
Good morning, everyone. I, Tanmay Tinkar, deem it a great honor to propose a vote of thanks on this event. On behalf of Vivek College of Commerce, I take this opportunity to propose a vote of thanks and thank all the audience who have contributed directly and indirectly through this session. I propose the vote of thanks to the Center of Innovation, Incubation and Entrepreneurship for organizing this event and proposing the and giving us the knowledge about the IPR session. I want to also thank you, Tanu Singh ma'am, for giving us the knowledge about the IPR. I also want to thank Dr. Vijay Hetty ma'am, Anuja ma'am, Anupama Bali ma'am, Dr. Tangadure sir, and Tenzin ma'am for giving us this platform and conducting this successful event. Lastly, I want to thank the team of Center of Innovation, Incubation and Entrepreneurship for giving us this for conducting a successful event. Thank you.
Thank you so much. Thank you. You all have a good day.
Thank you so much.
We really got so much to learn from you. Thank you so much, ma'am.
My pleasure. My pleasure. Thank you. Have a good day, all of you.
Yes, ma'am.
Bye.